SMU constitutional law professor Dale Carpenter, thank you so much. As we all know now, Roe v. Wade has been overturned. So I want to know, how significant is this from a legal point of view?
Well, this is probably among the most important decisions that the Supreme Court has issued since it issued its opinion in Roe versus Wade. This is one of the biggest, and in some ways it's almost unique.
And when was the last time that a federal right has been taken away and sent back to the states?
The court has not overruled a fundamental constitutional right in at least 80 years, back during the Great Depression, when it said that there was no longer a fundamental economic right to be free of all kinds of health and safety regulations in places like the workplace.
80 years.
80 years.
Wow, that's very significant. So when you went through the opinion, what was the basis for a majority of the justices to overturn Roe v. Wade?
There were really two main justifications offered by the court. One of them is that substantively, the court said there is no basis in the Constitution, in the text, the history, or the prior precedents from the court for any fundamental right to abortion. There was just nothing there. So the opinion was wrong. And then the second grounding was that, in addition to the fact that the court was convinced that it was wrong, there were no extraordinary reasons really to stand by the decision. And because it was so egregiously wrong and had done so much damage, the court said, it should be overruled. So you don't need to stand by that decision. Both parts of that ruling were significant.
And basically that the text was not in the Constitution, and therefore this should be overturned. Is that right?
That's right. There's nothing in the Constitution that specifically mentions abortion. There's nothing in the Constitution that specifically mentions abortion, and therefore, unless you can find it somewhere deep in the history and traditions of the country, it is not protected at all. And the court said, in our review of the history and traditions of the country, there is no such protection for abortion, certainly not going back deep into the history of the country.
And so in this ruling, was there any mention that other rights could be taken away?
Well, the court went out of its way, I think, on no fewer than 4 different occasions in the course of an 80-page opinion to say no other rights are at stake. Marriage rights for gay couples are not at stake. Rights of intimacy are not at stake. Contraception is not at stake. So the court really does try to assure us that nothing else is involved. It's just abortion.
And was there anything in the concurring opinions that stuck out to you?
Yes, actually, Justice Thomas issued a concurring opinion in which he said, well, I agree with the court that abortion is wrong, but I also think all these other precedents involving things like same-sex marriage and even contraception, those were wrong too. And the next step ought to be that we should overrule those decisions. And then Justice Kavanaugh had his own separate concurring opinion in which I think he tried to explain the basis for his conclusion that you didn't need to stand by Roe versus Wade. And he also emphasized that nothing in the opinion should be read to undermine rights to things like contraception and same-sex marriage.
So that's a contrast of opinions right there.
Yes, one justice going out of his way to say it's over for these unenumerated rights, or it should be, and one justice saying, no, we really do mean it when we say we're limiting this just to abortion.
What about the dissent? Anything that stuck out there?
Well, I think the dissent placed a great deal of reliance on the idea, just as the briefs did for abortion rights supporters, that there were 2 things really importantly at stake here. One was the fundamental bodily integrity and autonomy of women as it relates to decisions over having families and children and so forth. And there's a fundamental matter of women's equality involved, that they need to be able to control their reproduction in order to be able to control their lives, really, and that their health is really at stake in a way that is quite profound. And second, the dissent said that the court has practically abandoned its usual adherence to precedents. And here we have a 50-year-old, half a century precedent that the court has abandoned.
And is this final, or could, with the change of the court and perhaps more liberal justices, and another case comes back, could this be restored?
I think we've now learned that nothing that the Supreme Court decides is ever really final, and that while precedents of the Supreme Court are hard to get rid of, they can be eliminated over time, at least if you are determined enough and appoint enough justices over time with a different view. This decision, by the way, is the crowning legal achievement of the conservative legal movement. Without any question whatsoever, it is the product of literally decades of efforts to have Roe versus Wade overturned. And it's a great victory for that movement today, without any question. And the justices who decided this case, several of them are in their 50s, and they may be on the court for another 20, 30 or so years. So it may be quite some time before presidents have enough appointments to be able to reverse course yet again on the question of abortion rights. I think abortion rights supporters are going to need to try to find protection for the right in the political process now, not so much through the judicial system.
Here in the state of Texas, there's a trigger law that will go into effect 30 days after it becomes official at the Supreme Court. So we could be talking about 55 days. Could there be legal challenges to the state's rule that could go up to the Supreme Court, or no? And would those challenges have to go to the Texas Supreme Court instead?
Well, depends on the nature of the challenge. If the challenge was to the interpretation of the Texas law, that would most likely go through the state courts. If the challenge was based on federal constitutional principles or rights, that would most likely go through the federal courts and ultimately end up before the Supreme Court. Let's note importantly that what the court specifically decided in this case was, of course, to overrule Roe versus Wade. But the only abortion regulation it actually upheld was the Mississippi regulation that stops abortions after a period of 15 weeks and makes exceptions for medical emergencies and severe fetal abnormalities. So laws that don't make exceptions like that and try to draw the line earlier, perhaps in the pregnancy, and eliminate the abortion even earlier, will at least theoretically possibly be up for challenge in the future. And I'm sure they will be the subject of future litigation, may not be successful, but these are ambiguities that can be tried out, in addition to a host of other possible regulations that states may now want to try to enact.
So if I heard you correctly, you're saying that because the Supreme Court upheld the Mississippi case and the 15-week ban, does that mean all the states like California and New York that allow abortion have to live by the Mississippi standard now?
No, those states are entitled to have their own abortion laws as of now, unless Congress tries to override or successfully overrides those. They can have their own liberal, more permissive abortion regulations. The question, I think now, one of the many questions now on the table is going to be, what if some of the anti-abortion states try to control the ability of their own citizens to go out of state to obtain abortions? Can those states place restrictions on their citizens from traveling out of state to get those abortions? That's one of the issues that Justice Kavanaugh tried to deal with in his concurring opinion. He said that they could not do that. Another question that is going to arise, I think, potentially is, Could an abortion that was performed before the effective date of the court's decision itself be punished? And again, Justice Kavanaugh tried to deal with that by saying, no, you can't make something a crime or impermissible after it's already occurred. So these are questions that are now going to be on the table potentially before the court.
My last question, and that is because there is a discussion by some Texas Republican lawmakers to do what Justice Kavanaugh had mentioned, and that is they're considering a bill, hasn't been filed yet, but they're considering a bill that would not allow companies and individuals to pay for a woman to travel out of state to get an abortion. And so that would be challenged, I guess, in federal courts and also perhaps state courts too, right?
That's right. I think there will be challenges to a restriction like that. And there could be a number of potential challenges to that sort of restriction, including Justice Kavanaugh mentioned it specifically in his opinion, a challenge based on the constitutional right to travel, which, by the way, is also not mentioned in the Constitution, although the Supreme Court has in the past at least said that such a right is protected.
All right. SMU constitutional law professor Dale Carpenter, we thank you for all of your insight on this very significant ruling. Thank you so much.